Assalamu alaikum, good afternoon and greetings to all. My name is Munir Abdul Rauf. I am a member of the Law Faculty at the University of the Western Cape. Welcome to the webinar titled Muslim Personal Law, MPL in Muslim Minority Countries, a case study of MPL at the International Peace College of South Africa. This webinar is hosted by the Muslim Personal Law Unit, which is an established permanent specialized unit in the Center for Legal Integration in Africa. It is clear. And the unit is under a project titled Muslim Personal Law Unit. The unit's members are Professor Najma Musa, myself, Professor Munir Abdul Rauf, Dr. Ashraf Bulli, Dr. Latifa Mani, and Mr. Hussein Sangari, who also serves as the unit's administrator. The webinar of this afternoon will be presented by Dr. Dawood Terblanche, who is the CEO at IPSA. And before we present Dr. Dawood Terblanche with the opportunity to present, I'll give an overview who the presenter is and which institution he comes from. Dr. Dawood Terblanche holds a PhD in philosophy with a specialization in religion from the University of KwaZulu-Natal in Durban, South Africa, and an MA in ancient languages and cultures. His research areas include Islamic education, Islamic law, philosophy, religion, anthropology, history, and halal studies. He is currently the CEO of the International Peace College South Africa, the first accredited and registered private Islamic tertiary institution in South Africa. He also serves as a trustee of the Muslim Judicial Council Halal Trust in Cape Town, a trustee at the Voice of the Cape, a local Muslim radio station in Cape Town, and a member of the Animal Ethics Committee at UCT. Dr. Terblanche is also an external examiner and moderator for 3 public universities in South Africa. He's also a community leader for the past 20 years and currently serves as the resident imam at Nurul Huda Masjid in Cape Town. Dr. Terblanche is a sworn translator of the High Court of South Africa, as well as a marriage officer for the Department of Home Affairs. So with that very interesting introduction, I hand you over to Dr. Dawood Terblanche.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Shukran, Professor Munir Abdul Rauf, for that introduction. I do hope everybody can hear me. Is that correct?
Yes, you are audible, Dr.
Thank you, Dr. Munir. Okay. So, shukran, Professor Munir Abdul Rauf, for inviting me to do a presentation titled Muslim Personal Law in Muslim Minority Countries, a case study of MPL at the International Peace College South Africa at IPSA. Before I delve into the topic, allow me to give a brief history of the International Peace College South Africa, IPSA. So IPSA is situated in the heart of Rylands, corner of Johnson and June Road, Rylands. It was in the early 2000s that negotiations started taking place between 2 leading Muslim seminaries in Cape Town, namely Islamic College of Southern Africa, known as IPSA at the time, and also Darul Arqam Islamic Institution, or DAI as it was known. After intense negotiations in 2005, IPSA was established as a private Islamic tertiary institution. IPSA became the first private Islamic tertiary institution in South Africa to be accredited and registered with the Department of Higher Education. There were a few changes in the name, like we've had previously the name International Peace University South Africa. We also had the name International Peace Varsity South Africa. And this was mainly due to the Department of Higher Education and Training's regulation governing private tertiary institution, whereby the term university was designations for public institutions only, and therefore we landed up with International Peace College South Africa. So it was in 2013 that IPSA received the accreditation and registration for its programs. And the first program to be accredited was the 3-year bachelor's degree in Islamic studies. And since then, additional programs were added to its bouquet of offerings. So alhamdulillah, we have 4 programs accredited with the Department of Higher Education and Training. And that is a 1-year high certificate in Islamic studies, a 3-year bachelor's degree in Islamic studies, a 1-year honors degree in Islamic studies, and a 2-year master's in applied Islamic thought. So IPSA is founded on 3 main values, and that is knowledge, virtue, and civilization. So IPSA's vision is to build IPSA as a center of excellence in Islamic tertiary education and research. This vision is underpinned by a mission statement that defines IPSA. It can be summarized as to revitalize and synthesize the intellectual and spiritual dynamism of the Muslim community, to advocate the Islamic objectives and social cohesion based on the principle of relevance to context and distinctive integration, to nurture an environment that fosters intercultural understanding, pluralism, civilizational dialogue, to prepare students and academics to play a catalytic role in the creation of a just social order on earth based on peace and dignity for all humanity through ethical leadership. At IPSA, we believe that we must return to what has made us a proud civilization. In the preservation of Islam at the Cape, IPSA believes that the discursive discourses within the historical legacy of Islam must be relevant. Thus, emphasis is placed on the philosophical framework of fiqh al-waqi, the jurisprudence of reality. Our students engage on a scholarly level, unpacking questions on the why and how the Islamic legacy should be applied to real-life situations. The intellectual paradigm and methodology in which fiqh al-waqi is rooted is the grand objectives of Islam, or the maqasid of Islam, where the preservation of deen, religion, nafs, the life, the nasab, the lineage, the aql, the intellect, and the property, and the mal, the property, is at the center. And here we'd also like to add the identity, which is taken from Surah Hujurat, verse number 13. Where the Almighty says, Ya ayyuhan nas, inna khalaqnakum min dhakarin wa untha, wa ja'alnakum shu'uba wa qaba'ila lita'arafu. O mankind, indeed we have created you from a male and female, and have made you into nations and tribes so that you get to know one another. What we face as a Muslim community on the southern tip of Africa may be different to what Muslim communities face elsewhere, or there may be similarities in experiences. South Africa does not face the nuances and challenges that Muslims face in the West and Europe. The South African Muslim chapter is certainly unique and admired by many Muslims globally, and therefore we have an obligation to safeguard and to protect it. We look at 2 giants that has written extensively to a Muslim audience who find themselves in the West, like the renowned Dr. Yusuf Al-Qardawi, who visited South Africa a few years ago. And he predominantly speaks to the Muslim audience in the West, and he has authored more than 120 books, both in Arabic and the English language. And these are just some of the books that he has authored. Then also we have other renowned scholars in the form of Tariq Ramadan, who begins to speak to the audience living in Europe. And so the experiences of both the Muslims living in the West and those living in Europe, there are some similarities and there are some differences. And these are just some of the books that they have authored in which they speak to the Muslim audience living in the West and in Europe. There must be a return to our Turath al-Fiqhi, where scholarship, stewardship, ethical leadership, islah, restoration, and coexistence coupled with justice, social activism, research, transformation, and publication define Islamic civilization. Our classical legacy of Islamic law, or Turath al-Fiqhi, never separated between the development of Islamic law and the reality as we know as al-Waqi. A distinction in navigating these discourses is the ability to draw a clear separation between the immutable laws of the Almighty and also the variable. Often some scholars fail to understand that the drafting of fiqh and the codification of laws were influenced by time, by space and circumstances. And therefore, it was not strange for scholars in the past to have had an opinion and to change it later, like we know of Imam Shafi'i, who changed his opinions during the last 4 years of his life when he decided to move to modern Egypt. So Imam Shafi'i may be one of those scholars who have a number of opinions defined as al-Qawl al-Qadim, the old opinion, and al-Qawl al-Jadid, the new opinion. Likewise, other scholars too, like Imam Abu Hanifa, Imam Malik, and also Ahmad ibn Hanbal. Al-Qardawi argues that modern scholars must be able to understand the wisdom behind the laws and that the solution for contemporary fiqh cannot be absent from the principal values of the Turath al-Islami. He asserts that some modern scholars have forgotten this legacy. The universality of Muslim personal law is rooted in one, the scope of usul al-fiqh and the maqasid al-sharia. Number two, the notion of taysir. Number three, the concept of wasatiyya, moderation. And number four, the fundamental building blocks of ijtihad and fatwa. The Prophet ﷺ is reported to have encouraged his followers to embrace the easier option. And this hadith is recorded by Bukhari and also Muslim, in which it was reported to us by Sayyidina Aisha that when the Prophet ﷺ was confronted with a selection of two opinions, he often chose the one that was more easier as long as there were no sin involved in it. IPSA is fully aware that it operates and functions within a Muslim minority country. The challenges faced by Muslims today can be attributed to the willingness and flexibility to move between the various schools of thought, the madhahib, in certain areas. The example of the MMB discourse is cited. And I think we may be familiar with the long discourse and discussion of a proposed MMB Muslim marriage bill that is currently shelved since 2010, although it has gone through many drafts since 1994. The socio-economic impact of divorce and the consequences thereof is often not discussed, nor are there preventative measures put in place to mitigate the abuse of divorce, leaving divorced women vulnerable. The regulation of Muslim personal law is absent in South Africa. The only recourse for married Muslim women is to approach secular courts in South Africa to access justice. And here perhaps I would want to make mention of three particular case studies. There are more, and I perhaps want to deal with one or two whereby the women have approached the courts for relief. The 1996 case, Rylands versus the Edros case, where Mr. Rylands and Mrs. Edros were married to each other in terms of Islamic law. The marriage was dissolved in terms of Islamic law. What then happened subsequently was that Mr. Rylands instituted an action in court to evict Mrs. Edros. Mrs. Edros then instituted a counterclaim in three areas that she wanted. Number one was area maintenance, a consolatory gift, and for an equitable portion of the growth of Mr. Rylands' estate. So the relief was sought in terms of Islamic law. The then Cape High Court held that a marriage contract in terms of Islamic law generated a legal contractual duty upon the husband to support his wife. Mrs. Edros was thus entitled to claim unpaid area maintenance. And so what was used here was the Prescription Act of 1969, which only allowed her to claim for a period of 3 years. The court also held that Mrs. Edros would be entitled to a consolatory gift or a departing gift if she could prove that the divorce was at the behest of Mr. Rylands. So if the MMB that has been shelved since 2010, it would have at least allowed the wife to claim area maintenance dating back to quite a considerable time, more than the 3 years provided by the Prescription Act of 1969. It also would have allowed the wife to receive a departing gift. There's also the case of the Daniels versus the Campbell case in 2004, where Mr. and Mrs. Daniels were married to each other in terms of Islamic law. The marriage subsequently dissolved in terms of Islamic law through the death of Mr. Daniels. Mrs. Daniels subsequently sought relief from the court in terms of the Maintenance Surviving Spouse Act and the Interstate Succession Act. The Constitutional Court held that parties to a de facto monogamous marriage, Islamic marriage, should be covered in terms of the Maintenance of Surviving Spouses Act and the Interstate Succession Act. The relief was granted by the court without considering whether Mrs. Daniels was entitled to claim maintenance from the deceased estate in terms of Islamic law. The question as to whether Mrs. Daniels was entitled to inherit from the interstate estate of the deceased spouse in terms of Islamic law was also not considered by the court. So in these two cases, we can see that from time to time there were merits in visiting the court. And also there were sometimes that the courts then applied the mind and provided the relief sorted in some cases. This is a double-edged sword, which at times are just and at times a concern when it violates the Islamic law. So secular courts may pronounce or pass judgments that may be contrary to Muslim personal law in Islam. The actors accused of perpetuating the sufferings of Muslim women are government who have failed to recognize Muslim marriages since the advent of democracy in South Africa. Also, prominent Muslim organizations must also take some responsibilities for the non-recognition of Muslim marriages more than 28 years into our democracy. The lack to lobby government and to hold them responsible is worrying and concerning. On Tuesday, the 28th of June, 2022, the Constitutional Court handed down judgment in an application brought forth by the Women Legal Center to confirm an order of the Supreme Court of Appeal. The order declared the Marriage Act 25 of 1961, the Divorce Act 70 of 1979, and certain provisions of the Divorce Act to be inconsistent with Section 9, 10, 28, and 34 of the Constitution, in that it failed to recognize Muslim marriages solemnized in accordance with the Sharia law as being valid for all purposes in South Africa, and to regulate the consequences of such recognition. The Constitutional Court has given government 2 years to amend the Marriage and the Divorce Act. So there has been some changes in this particular regard, but no clear guidance and update of the Marriage Act that will lead towards the complete recognition of Muslim personal law governed by the tenets of Islam and the Sunnah of the Prophet Sallallahu Alaihi Wasallam. And the strange part is that the regulation of Muslim personal...
Yeah, just to break in there, Sheikh, there seems to be an issue with the PowerPoints. It's not changing on our side.
Oh, okay, so it's changing on my side, Dr. Munir. Let me just stop sharing and I'll try to go again into it.
Okay. The technical person said that you have to change it, yeah.
Okay, can you see, Dr. Munir?
We can still see brief history of IPSA.
Oh, no, it's showing, what's showing on my side is approaching the courts a double-edged sword is showing on my side.
Maybe Muhammad Sangay and Terry can just assist quickly, inshallah. Okay, now we see the new one.
Can you see that one?
Yeah, we can see that, yes.
Okay, so I'm almost at the end. Okay, so what is strange is that the regulations of Muslim personal law has been legislated in many Muslim countries such as Malaysia, Indonesia, and many other Muslim countries for decades now. And unfortunately, in South Africa, it seems to be, a struggle because of our unity as a community. Sometimes we hear comments that Islam is so unjust that men have access to 3 discretionary divorces. But if we delve into the Islamic law, we find that women have the access to what is known as a fasakh, also a khul, and also tafweed, the ceding of divorce. And this is seldom spoken of. The wife, in fact, dictates the terms of her marriage, for which the husband to be must either consent or negotiate or walk away from that which the wife wants. And so what IPSA has done in this regard as part of the honors program in the module Contemporary Islamic Law is that our students have drafted a Muslim marriage contract and aligned it to constitutional imperatives and our rich legacy of Islamic law. So I do think that this must still take off, and we still need to speak about all of these rights and options given to women, and sometimes even the whole concept and the legal framework of the ceding of divorce by giving the right of divorce to the wife is often not spoken of. And according to the scholars, that this discussion can happen at the time of a marriage contract. Also, the whole legal framework of who, where the wife then returns the right of dowry given to her at the beginning of the marriage in order to exit from the marriage is also considered in Islam. Then the challenging part, of course, is the fasakh, whereby the wife will have to approach a Muslim organization for such relief. And at times, some organizations would advance the issuing of a divorce based on her criteria as set. And at times, a divorce is not granted to her because of insufficient reason. This, of course, becomes a major challenge for us. Then, critical discourses in the study of wasatiyah, maqasid al-sharia, the grand objectives of the sharia, fiqh al-watan, the jurisprudence of citizenship, fiqh al-waqi, the jurisprudence of the present, and the fiqh al-aqalliyat, the jurisprudence of minorities, are important intellectual traditional scholarships which have influenced the codification of Islamic law over centuries. This will allow for the crafting of a more inclusive Islamic legal framework underpinned by justice and the spirit of the law. The tajdeed renewal of usul fiqh, Islamic jurisprudence, must be taken into consideration to balance between the dictates of Islamic tradition and the waqi, the reality. In conclusion, a few years ago, there was a debate between the Grand Imam of Al-Azhar, Shaykh Ahmad Al-Tayyib, and Muhammad Uthman Al-Ghasht, president of the Cairo University, and this particular debate went viral. The president of the Cairo University, Dr. Ghasht, argued that Islam needs renewal by returning to the Quran and the authentic Sunnah. He blamed tradition for preventing advancement in the modern Muslim world. He argued that Islamic tradition had become stagnant and that if Muhammad ibn Idris al-Shafi'i was alive today, he would have also sought to renew Islamic law. Tayyib responded with a passionate rebuttal and defense of Islamic tradition. He noted that even the idea of religious renewal is from the tradition itself, not from outside. He compared Ghasht to someone who seeks to renovate his father's home but opts to buy a new one instead. Ghasht is not alone. Many modern Muslims view the Islamic legal tradition as needing a complete overhaul. For those wishing to read and to have greater insight into the debate and arguments, can refer to the article written by Dr. Ahmed Al-Hamdi, who is an assistant professor of Arabic and Islamic Studies at Embry-Riddle University. His article is titled, "What is a Madhab? Exploring the Role of Islamic Schools of Law." At IPSA, we believe that our students must be introduced to these discourses, the universal concepts of principles of Islamic law, maqasid al-sharia, the grand objectives of the law, the fiqh of minorities, the fiqh of citizenship, the fiqh of realities, and the fiqh of minorities. This will allow them, our students, to craft a pathway where the identity of Muslims can be preserved for generations to come within the dynamic framework and teachings of Wasatiyah. IPSA's programs are orientated towards balancing the rich Islamic tradition of scholarship and the Quranic worldview of justice with critical discourses facing Muslims in the Muslim minority countries without compromising their identity. The Muslim world today is facing unprecedented challenges, and Islam largely is an untapped reservoir of ideas and approaches that can potentially address them. Although Islam is a religion of approximately 1/4 of the world's population, contemporary Muslim contributions have fallen well behind its historical legacy. Moreover, core Islamic values that include unity of humanity and creation, seeking knowledge, and establishing justice, welfare, and peace have found little expression and application. IPSA's postgraduate programs in particular sets to bridge this gap in its honors in Islamic studies and masters in applied Islamic thought. At IPSA, we balance between the rich intellectual tradition, the legacy of Islam, and fiqh al-waqi', the jurisprudence of reality, with the concept of wasatiyah to provide meaningful application and relevance to Islamic law. Dr. Munir, that is my presentation, and shukran to those who have tuned in and listened.
Jazakallah khairan. Thank you very much to Dr. Dawood Terblanche from IPSA for that presentation entitled Muslim Personal Law in Muslim Minority Countries, a case study of MPL at the International Peace College South Africa, that is IPSA. Right, our previous webinar looked at the application of Muslim personal law in South Africa and the stance of the Muslim Judicial Council as an Islamic institution. And today we have the benefit of having the CEO of an academic institution from IPSA. And as we know, IPSA is the first Islamic institution registered by the Department of Higher Education and Training, that's DHET, in South Africa, offering accredited programs in the BA, Certificate in Islamic Studies, and so forth. So thank you very much for Dr. Dawood Terblanche, shukran, jazeeran kathiran, for that presentation. Right, so if there are any questions, it can either be put in the chat box, or alternatively, you could just raise your hand. You can identify yourself, your name, and the organization and affiliation, and pose your question, and thereafter Dr. Dawood Terblanche can then respond accordingly. Right, so if there's anyone, I see there's Muhammad Hussein Sangay. You may proceed.
Assalamu alaikum, Dr. Dawood, and shukran for the opportunity to ask my question. In advance, I'd like to apologize for coughing or anything. I'm just feeling slightly under the weather. But my question revolves around a question rather about Muslim minority countries. Alhamdulillah, in South Africa, we are increasing. I think the latest statistic shows that us as Muslims are between 3 and 5% of the total population of approximately 60 million people. And Dr. Dawood excellently outlaid that our court structures and approaching our court structures is a double-edged sword. So I would like to know, Dr. Dawood, in your opinion, is there any other Muslim minority country that Doc believes that we could perhaps follow or work on to better our situation? Considering that sometimes courts rule in favor of Muslim personal law and sometimes against Muslim personal law.
Yes, I think there was a number of studies when the MMB was drafted, and a number of comparative studies as to what model we should be using. And so, the countries that do come to mind, and maybe Dr. Munir can also jump in here, you had, Mauritius, you have the Singapore model was also looked at. You've looked at, the Malaysian model that was also looked at. And so these are just some of the countries whereby there was some sort of a leeway in the application and understanding of how best it could suit also a Muslim minority country like that is South Africa. Also, we've seen largely, what's happening in India, whereby the Muslims are also, a minority, but they have, they had their legislations predominantly over the years, confined to Muslim personal law. So that is also changing. So there are some of those particular countries. However, I think what needs to be made mention of, that throughout the Muslim world, is that there is no one shoe fit all when it comes to Muslim personal law. So countries, there has been at least an attempt by the GCC countries to at least have some sort of unity in Muslim personal law, but they haven't really reached that particular ideal. So although we can, refer to Singapore, to Mauritius, to India, to some of the GCC countries who are predominantly Muslim countries, one would say that, we have to look at, our reality, what is on the ground, and what would be best suited, for the Muslim audience itself. Like we'd find Dr. Yusuf Qardawi and also Tariq Ramadan, they speak to two different audience, and the experiences of Muslims living in the West versus Europe is vastly different. And therefore, the legislation that they have put into place, the guiding principles, has also been a bit different from one place to the other.
All right. Shukran, Jazakallah. We thank Dr. Dawood Terblanche for that comment. As we know, yes, Muslim minority countries there is a problem of its application. And I've recently been in Mauritius and also in the UK. And when we explained that South African position and what has happened here in the history, many times they say that there's a lot for them to learn from us. So that is quite an interesting study in this regard. Inshallah, we still the floor is still open. Are there any further questions?
I see a hand there by
Munira
Munira
Osman. Yes, you can go ahead. That is Dr. Munira Osman. May go ahead.
Assalamu alaikum wa rahmatullahi wa barakatuh. Shukran for allowing me this opportunity. It's Munira Osman from Regent Business School and a long-time advocate for the recognition of Muslim marriages in South Africa. So my question is around the concept of khula. And there's a huge debate about whether this equates to the woman's right to divorce in many circles. And so I'd like clarity on that, because the debate basically has 2 points. One is that it's the wife's right, and therefore she can use it when and as she pleases, which I don't think is the correct position. And the other is that it is a process available to her to initiate the discussions, which is my understanding, around an exit of the marriage, and in terms of which she offers the return of the meher. So perhaps, I'm not sure, how is this particular concept broached at IPSA, and how are students reacting to this concept of khula?
Thank you for that question, Dr. Munira. Yes, so definitely, if we are looking at the legislation and our Turath and our legacy, when the woman did approach the Prophet ﷺ for this annulment, in which the Prophet understood it to be an annulment, the Prophet did ask the man whether he would have been, whether he is ready, to accept it. And on his acceptance, this whole discussion of the khul'a, begins to take place. However, this becomes an avenue to explore, that the wife can explore. And I think the challenge that we are sitting with today is that there is no real recognition given to the anxiety that the wife would experience inside of her marriage. In other words, when she approaches a court, it is after a number of years in trying to attend to her challenges inside of her marriage, to deal with the differences, and she just didn't wake up one day and decided to approach the court. So this is a concern, that is real, and sometimes, organizations don't really understand, and empathize with what the wife has gone through. So our students at IPSA, when we are dealing with this particular topic of whom, they understand that there is an avenue for them to explore. And also what is very interesting is that, as I've indicated previously, is that there is a contract that seems to be absent in many marriages today. There's often an assumption that the marriage, yes, will last for eternity until death do them part. However, when we are looking at a contract, that these particular avenues can be explored, but it will have to be agreed upon by both parties, as long as there is no violation of the commands of the Almighty. So something like this can be explored if we are perhaps identifying what are some of those particular challenges that women may experience in the subsistence of the marriage or later on. And so when these particular anxieties or stress levels or challenges are experienced, then the wife would then have at least an option to return the dowry to the husband in order to exit from the marriage itself, because he may not be really the person who has neglected his responsibility, and the hadith of Prophet really speaks to that. But however, the wife may have lost interest in the husband, and therefore he needs to understand that and allow at least that particular exit from the marriage itself. So it can be built in, I believe, into the contract of a marriage. So it is received quite well, Dr. Munira, by our students here at IPSA.
Okay, shukran for that, Dr. Dawood. Just a comment by Professor Najma Musa. As we know, there's also attending the Muslim personal law students as one of the electives in the final year here at the University of the Western Cape Faculty of Law. And the student basically just requested if it's possible to get the article that Dr. Dawood Terblanche has referred to in the presentation. Right, so that's a question. And I think Professor Najma Musa also wants to make a comment. So I hand over to her.
Yes, Shukran Munir. Actually, I was just going to ask the very same question, the article about the malhabs that you were referring to. If you could possibly email it to Professor Munir, and then I can circulate it to the students. I just wanted to thank you for that.
I will definitely do that, Professor Najma. Dr. Munir, I will do that.
Shukran, and thank you for that. There is a comment in the chat box. He says, I do not have a question. I just want to thank Dr. Dawood Terblanche. This was an incredible illuminating presentation. I am a new lecturer at the University of Western Cape, and I teach research methodology to the third year law students. I usually encourage my students to bring their culture and religion into their intellectual engagement with the law by way of scholarly research, especially in the field of legal pluralism. Thank you for this. I am learning. Right? That is a comment by one of the lecturers. So the webinar is basically is really thought-provoking and informative. There's another question or comment here. How can we collaborate to make the application for FAS less challenging for women? Maybe Sheikh Dawood can respond.
I think this is, where the challenge is. And, I said to my students last week when we've had this discussion on fasakh, a judicial, a divorce where the wife has to, approach the courts. And I've just put it out there and I said to our students what we are witnessing today in the Muslim world, if you're looking at Saudi Arabia and also Malaysia, is that they are moving towards Muslim women judges and who are overseeing, divorces nowadays. So there's quite a bit of articles, on this. And I said to our students, that perhaps, it is time that we need to perhaps, challenge a bit the status quo and see how we can come up with some research in, seeing to the establishment of, additional Sharia courts whereby women are also, overseeing these particular courts. I know it's extremely contentious issue. It is a space where mostly that is, controlled by the ulama, the men. But there is, a discussion within Islamic law that do also allow females to, take up this particular leadership responsibilities. And perhaps, that could be one avenue, but also in institutions like IPSA, whereby, we are trying to produce scholars who are well engaged with its legacy, its turath, to assume also these particular responsibilities and to enter into these particular organizations and to perhaps look at things differently. So I know I threw a cat between the pigeons, Dr. Munir Abdul Rauf, but I think a discussion around this, we should be having.
Yes, Jazakallah. Thank you for that, Dr. Dawood. I think there might be enough time for one more question. Any burning question from any of those present? All right, I see there is a comment by Professor Diala, who is also the director of CLEAR, right? That is now the Center for Legal Integration in Africa. And basically he says, thank you very much, Dr. Terblanche, for your insightful engagement on comparative Muslim personal law. All right, we appreciate your expert knowledge exchange and look forward to further collaborations with the University of Western Cape. Professor Anthony Diala is currently not in Cape Town. He's actually at an event in Iceland at the moment, but he, however, logged in and was listening attentively, and that is his comment in this regard. So we're looking forward to this collaboration, and that is directly from the director of the Center of Legal Integration in Africa. There's another question here. It says, Assalamu alaikum, hope all is well. I'm a final year LLB student at UWC. I'm currently taking a module entitled Muslim Personal Law under the guidance of Professor Najma Musa, who's now with us on this webinar. One of the suggestions some academics have noted is about the possibility of having separate courts dealing with Muslim personal law in South Africa. What are your thoughts on this? Maybe Sheikh Dr. Dawood can give your thoughts.
Is that question directed at me or Prof?
I think, yeah, maybe this comment, yeah, I don't know. She's saying that she is in the doing the LLB with Professor Najma Musa, but the question is that should there be separate courts dealing with this? From an academic discussion, what does IPSA stance on this matter, or any comment, if any?
No, I do believe that we do support, separate courts, and it's just a matter of how it will, operate. And so I do think that, we need to be seriously looking at the regulation of Muslim personal law, because right now, female women are suffering, and it's quite expensive to approach our courts, the secular courts. So I do believe that, if we come together and we are able to, pick up this conversation with government, is something good. But at the same time, is that, it's going to be difficult for the Muslim community to agree, upon that would be the ideal thing for us, for the Muslims to come together and, establish a court, and everybody goes to that particular court, in every province, 2 or 3, that is run by the Muslims. That's the ideal. And I don't know whether that would be possible, taking into consideration how different we are, and some of, our understandings of Muslim personal law that may vary. That's also, challenging. But I do believe, and I do support that there needs to be, the courts that needs to be made available that deal specifically with Muslim personal law.
Jazakallah, thank you for that. I remember that the statement always made at the Muslim Judicial Council concerning this matter, and I think Mullah Taha also stated that when the ANC government came into power, the question was, do we have our separate courts? And then this was something that was pushed by the Muslim Judicial Council. But then I said, what is the alternative? And that was a discussion around that. But I do agree that this was always a stance of the Muslim Judicial Council, and I would say IPSA as well, concerning having these separate courts. I think there's 2 more questions, then we have to round up. Firstly, I see Professor Sulaiman Dango, and then lastly, we'll look at the question in the chat box. So Professor Sulaiman can go ahead and raise your comment or question. Professor Sulaiman Dango, are you there? All right, maybe there's a problem with the mic. We'll go to the last comment. This is from Aisha Abrams.
Okay.
Okay, Professor, go ahead.
Assalamu alaikum. I got 2 questions. First is, if the wife goes to a secular court and she obtains a divorce, what's the position of the Sharia board? Will they accept that? That's the first question. The second one is talaq tafweed. I mean, I think there's probably a lot of confusion about it. And some women believe that it gives an absolute right to give divorce to husband, the way the husband might just do talaq, talaq, talaq. Can you please clarify that?
I didn't get the first question, but just want to answer quickly just the second one on the tawheed, and that is exactly what it is. There are various opinions around the discussion, but I think the saving grace in the whole discussion about the tawheed is that it falls within the parameters of Islamic law, and I think that is what is required in a Muslim minority country. That if we will be facing and just opting for one viewpoint of one particular madhab, it will be extremely challenging. But if we are extending the conversation to include the opinions of other madhabs, I think we will do well in Muslim minority countries. And so there would be, a place for tafweed, despite the differences of scholars within the subject itself. The first question, Dr. Munir, about the secular court of the wife approaching, what was that question?
I think
Yeah, no, if the wife goes to a secular court and obtains a divorce, what's the position of the shaykh or the ulama? Will they accept that divorce in the secular court?
Yeah, I think that is a bit of the contentious one there. But I think Dr. Munir, I think he had some experiences in that previously under the MJC. Dr. Munir, can you perhaps come into this conversation, Dr. Munir?
Yeah, shukran to that, Dawood, yeah, basically, yeah, that is, as we stated, there's some contention around that, depending on how the parties are married as well, civilly and Islamically. And does a civil divorce, does that now dissolve the Islamic marriage and so forth? So I would say, yeah, it depends on which view is applied. But I don't know of any Islamic institution, at least on my reading currently, that has given a ruling on this matter. And that is probably what will happen very soon, seeing that there are many matters of this nature going to the courts of South Africa. All right,
I think one of the problems is that if they do not they insist on the talaq and the husband refuses to give the talaq, woman is in limbo.
Yeah. Yeah, and I think basically in that instance, and I think Dr. Munira Osman is here. She's written an article on that as well, I think quite extensively on that. Maybe she can give an input as well, if she'd like to. If not, yeah.
Okay. No problem. No, it's just that where the husband refuses to grant the talaq, doesn't leave the woman in a position where she has no redress. There's other methods that Shaykh referred to earlier on about how the woman can actually try and get her exit from the marriage. So that's why whenever we discuss these matters, whether it's academic circles or any of these circles, I don't refer to it as a divorce or just a talaq, but rather which are the various ways in which a Muslim marriage can be terminated. So yes, Prof. Doingo, there are other ways in which the woman can seek. It's not as easy as the talaq procedure, and it's not discretionary like the talaq, but those procedures do exist nevertheless.
Shukran for Dr. Munira. I think the last two is, there are two comments. The one is by Aisha Abrams and the one there is by Mr. Babakar. I don't understand the question in the chat box, so maybe I can give, due to time constraints, maybe Mr. Babakar can just introduce himself and raise his question directly to Dr. Dawood. Yeah. You may go ahead, Mr. Babakar.
Assalamu alaikum. Assalamu alaikum.
Waalaikumsalam warahmatullahi wabarakatuh. We can hear you. Go ahead, sir.
Please, thanks to panelists and participation. I am a Francophone living in West Africa. I am a question, how your organization and action in the institutional OCE, because I am actor civil society, participate in reduction the text constitution of OCE. In 1980 summit of OCE in Dhaka. I would like if action to organize training knowledge with ISESCO and UNESCO and other university reflection in the situation. Thankfully, I am congratulated to continue this action of exchange. Thankfully.
Thank you very much for that, Mr. Babakar. Yeah, you can also get in contact with us. I think that's more directed towards the University of Western Cape and these type of webinars and seminars, if I understand it correctly. Mr. Hussein Sangay is administrator of the Muslim Personal Law Unit, and you can then get our details accordingly after this webinar. But thank you for that comment. Lastly, I think before we close off, there's a comment here about Assalamu alaikum wa rahmatullahi wa barakatuh. As a social worker specializing in child protection and safeguarding, I would like to understand whether there is a module on family law and whether there are upcoming webinars, please. Yes, as stated at the beginning of this webinar, the Muslim Personal Law Unit is established as a permanent specialized unit in the Center for Legal Integration in Africa that is clear under the project Muslim Personal Law Unit. And basically, we have been established this year, and there's been a number of webinars of this nature. The Muslim Judicial Council has presented, the United Ulama Council of South Africa, has presented on webinars under the Muslim Personal Law Unit. And we are also looking at other presenters from other parts of the country as well as abroad internationally. So yes, you can make use of, basically follow us on LinkedIn, on the UWC website and so forth to find out more information. And also in the chat group, our administrator, Mr. Hussein Sangay, has put down the contact details in this regard. At the University of Western Cape, we have Muslim Personal Law. Professor Najma Musa is the lecturer over there that teaches that. And also we have masters in the master's program. Under CLEAR, we also have an Islamic law module. Right? So that is there. But it does form part of the LLB degree. Right? So you should basically be a student of law. Right, but you can basically contact us to get further information in this regard. I think that is basically all we have time for today. The questions are coming in. However, it's now 2:15, so the hour has basically come to an end. So firstly, I'd like to thank the presenter, Dr. Dawood Terblanche from IPSA, for that very interesting and informative presentation of Muslim personal law and what is done at the International Peace College South Africa. So thank you very much for that. I'd like to thank the CLEAR, the Center for Legal Integrations in Africa, for making this event available as well, and the director, Professor Anthony Diala, the members of the Muslim Personal Law Unit that I've mentioned at the beginning as well. And a very big thank you to the technical team that is now K, that has made it possible for us to have this webinar, as well as Mr. Hussein Sangay for working behind the scenes. And most importantly, we thank all the attendees for listening in and for making your comments and questions, or presenting your questions to the speaker. And thank you to one and all. We basically this is recorded, and a recording of this webinar will be made available, and you can look out for the link in due course. And we will be having many more webinars. I think this is the last one for this year, but next year we will have some very great webinars basically that will be presented. So thank you, and this is the end of the session, and it is officially adjourned. Enjoy the rest of the day. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.